My name is David Trahan, and I'm the Executive Director of the Sportsman's Alliance of Maine. Today we're going to be talking about LD176. This bill would stop out-of-state special interests from coming in here and buying their way onto the Maine ballot and ensure in the future that referendums belong to Maine people. This is my testimony on LD176 before the Legal and Veterans Affairs Committee. We will provide also an audio clip of Katie Hansberry, Humane Society of the United States, also her audio clip. I would encourage you to listen to her audio clip because the committee really questions her hard, and you can tell by her answers she's being very evasive, very defensive, and reveals really for everyone in Maine exactly what this outfit did. I encourage you to listen to her, but also listen to her answers, because you'll find, as in in her training, she's a Massachusetts lawyer that came to Maine. She's very evasive. She never really answers any questions. But it goes to show you that sort of who the folks are that we're dealing with. Honorable Senator Seaway, Representative Lucchini, members of the Veterans and Legal Affairs Committee, my name is David Trahan. I'm the Executive Director of the Sportsman's Alliance of Maine. And I'm here to speak in support of LD176, an act to amend the law governing the gathering of signatures for direct initiatives in the People's Veto Referendum. Article 4, Part 3rd, Section 20 of the Maine Constitution defines circulator for citizen petitions as means a person who solicits signatures, and I underline that specifically, and I'll get to that in a moment, for written petitions, and who must be a resident of the state, and who must appear on the voting list of the city, town, or plantation of the circulator's residence as qualified to vote for governor. This line in our state constitution appears pretty darn clear that in order to circulate a citizen-initiated petition to change law in Maine, you must be a registered Maine voter and be a resident of the state. Nowhere in Maine law or in the Constitution does it say Maine citizens can act as witnesses for non-residents who want to circulate Maine petitions. I stress this point. You must be a Maine resident to solicit a petition signature in Maine. So if the Constitution is clear, why is this bill before you? And why is it necessary? Answer: because groups from out of state, like the Humane Society of the United States, have found a very shady, if not illegal way to sidestep our state constitution, or our state constitutional requirement to be a citizen of Maine to collect petition signatures by using what they call resident witnesses. Their own online ads, which I provided to you and attached to your testimony, I'll get to that again in a second here, prove that this statement is true. In addition, they have used these witnesses as some sort of justification for using non-resident signature collectors as sort of migrant mercenaries to qualify for the ballot, not just in Maine, but in other parts of the country. I quote their online Craigslist ad. Maine requires petition circulators to be registered Maine voters. We pair you up with an expert out-of-state petitioner who loves this work so you can, quote, witness the petitions being signed. The expert's home states have no petition work at this time. In the case of the recently defeated Bear referendum, the Humane Society hired a California company called PCI Consulting, a longtime partner in such initiatives to recruit non-residents to come to Maine to collect signatures. They paid their travel and meal expenses for signatures and also paid for signatures collected. Maine Ethics Commission reports reveal they paid PCI Consulting $178,574 of their total $228,574 spent by HSUS to collect signatures. Although paying Maine petitioners for signatures to some is distasteful, it is not illegal. The Supreme Court has settled this issue in the case Meyer v. Grant in 1988. This bill has nothing to do with banning Maine petitioners or paid petitioners. This bill addresses a serious abuse of the petition process and establishes a regulatory structure that allows the Secretary of State to enforce the intent of Article 4, Part 3rd, Section 20. This is the process HSUS used, and I think it's important that you understand it. First, they hired PCI Consulting of California to recruit non-resident professional signature collectors from all over the country to travel to Maine. Those non-resident petitioners are never identified, and they are always unknown. There are no requirements that they either register or identify who they are. The only way that you could ever find that information out is if you asked them. And hopefully they'll testify later and somebody in this committee will ask them to supply a list of non-resident collectors. I doubt you'll get it. PCI Consulting pairs these non-residents with what they call Maine witnesses, or registered Maine voters. These witnesses act as surrogates that tag along as non-resident petitioners say and do whatever they can to get a signature, all for a buck. Because these witnesses and non-resident petitioners are unregulated, these witnesses can sit in the car next to the heater while they're playing handheld video games, while the non-residents circulate, and I again stress, solicit signatures. These migrant petitioners' identities are never revealed. Even in a sophisticated sting operation, you could not determine who is a resident and who is a non-resident when petitioning. Petitions are notarized days, if not weeks, after collection by the Maine witness, not the non-resident petitioner, who actually circulated and solicited the signatures. The intent of this bill is to create a process by which the public can determine who is collecting signatures, what state they are from, and stop unaccountable non-resident petitioners from misleading Mainers into signing petitions. In addition, these changes will strengthen the ability of state officials to enforce the intent of Article 4, Part 3, Section 20. The threshold for courts in determining the reasonable regulation of the First Amendment is rightfully high. But I would ask you this simple question. Does our citizen-initiated petition process really belong to Maine people when anyone in any corner of this world can pay $250,000 to a California company to bring paid petitioners to Maine and buy their way onto the Maine ballot? Finally, why, if the Maine witness is qualified to circulate and solicit petition signatures, does HSUS and other groups feel the need to bust non-residents into our state and blatantly abuse our Maine citizen petition process? If that is the signature collection process we are willing to accept as okay, then this committee should recommend the repeal of Article 4, Part 3, Section 20 of our state constitution and let chaos rule. After discussions with lawyers with an expertise in constitutional law, it is my intent to work with the sponsor of this bill, Representative Schuller, to carefully amend this bill to narrowly focus its provisions based on settled Supreme Court cases across the country, as to ensure that it is crafted in a way to best withstand a court challenge and to be careful to respect the right of free speech. We will bring that amendment to the work session.
As you can see in the video, in the audio, this is a contentious issue. Sam is a leader in the outdoor community. I encourage you to watch or listen to the entire segment. The entire public hearing was filmed and taped. The audio in particular is really revealing. It tells a lot about the sort of the folks that we are dealing with and what we're going to be dealing with in the future. Sam has several pieces of legislation and several different initiatives that we'll be putting forward during the session. This is just one of them. This is just the beginning. It's going to be a long session, but what we feel we have an opportunity to fix these problems once and for all. Well, thank you for tuning in. Make sure you monitor our YouTube channel, and we have a lot of exciting things coming forward, and we hope that you'll join us. Thank you.